À l'ordre.
Order.
On the question of privilege raised on March 18, 2010 by the Honourable Member for Scarborough-Rouge River, the Honourable Member for St John's East and the Honourable Member for Saint-Jean, concerning the order of the House of December 10, 2009 respecting the production of documents regarding Afghan detainees. Je remercie.
I would like to thank those three members raising these issues. I would like to thank the Honourable Minister of Justice and Attorney General, the Honourable Parliamentary Secretary to the Government House Leader, the Honourable House Leader of the Official Opposition, and Honourable Members for Toronto Centre, Joliette, Windsor-Tecumseh, Yukon, Toronto Danforth, Outremont, and Kootenay East for their interventions on this important matter on March 18th, 25th and 31st and on April 1st, 12th, 2010. The facts that have led the House and the Chair to be seized of this case are the following. On February 10th, 2009, the House recreated the Special Committee on the Canadian Mission in Afghanistan. This committee conducted its business in the usual way and began in the fall of that year to seek information from the government on the treatment of Afghan detainees.
On November 27, 2009, the committee reported to the House what it considered to be a breach of its privileges in relation to its inquiries and requests for documents. On December the 10th, 2009, the House adopted an order for the production of documents regarding Afghan detainees. On December the 30th, 2009, the session in which this order was adopted was prorogued. Le comité spécial a été...
On March 3rd, 2010, when the present session began, the Special Committee was reconstituted and resumed its work. Since orders of the House for the production of documents survived prorogation, the House order of December 10th, 2009 remained in effect.
In 2010, the Minister of Justice rose in the House to announce that the government had appointed former Supreme Court Justice Frank Iacobucci to undertake an independent, and I quote, to undertake an independent, comprehensive and proper review of the documents at issue, end of quote. The Minister described Mr. Iacobucci's mandate in relation to the order of December 10, 2009, specifying that the former Justice would report to him.
On March 16, 2010, the Leader of the Government in the House of Commons tabled the specific terms of reference for Mr. Iacobucci. On March 18, 2010, three members raised questions of privilege related to the order of December 10, 2009. A number of other members also contributed to the discussion.
On March 25, 2010, and again on April 1st and 26, 2010, the government tabled a large volume of documents regarding Afghan detainees without prejudice to the procedural arguments relating to the order of December 10, 2009. On March 25th and April 1st, the Chair also heard interventions from members. On March 31st, 2010, the government responded to the arguments made in relation to the questions of privilege raised on March 18, 2010. Enfin, le 1er et le 12 avril.
Last, on April 1st and again on April 12th, 2010, the Chair heard arguments on the questions of privilege from several members, took the matter under advisement and undertook to return to the House with a ruling.
Before addressing the arguments brought forward, I want to take this opportunity to remind members of the role of the Chair when questions of privilege are raised. House of Commons Procedure and Practice, 2nd edition, O'Brien and Bosk, at page 141 states, and I quote, "Great importance is attached to matters involving privilege. A member wishing to raise a question of privilege in the House must first convince the Speaker that his or her concern is prima facie, on the first impression or at first glance, a question of privilege. The function of the Speaker is limited to deciding whether the matter is of such a character as to entitle the member who has raised the question to move a motion which will have priority over orders of the day. That is, in the Speaker's opinion, there is a prima facie question of privilege. If there is, the House must take the matter into immediate consideration. Ultimately, it is the House which decides whether a breach of privilege or a contempt has been committed." End of quote. En tant que président,
as Speaker, one of my principal duties is to safeguard the rights and privileges of members and of the House. In doing so, the Chair is always mindful of the established precedents, usages, traditions and practices of the House and of the role of the Chair in their ongoing evolution. It is no exaggeration to say that it is a rare event for the Speaker to be seized of a matter as complex and as heavy with consequence as the matter before us now. Because of the complexity of the issues that have been raised and the large number of lengthy interventions made by honourable members, I have taken the liberty of regrouping the issues thematically in order to address the arguments presented more effectively.
The main and most important issue that the Chair must address today concerns the right of the House to order production of documents, including the nature of the right, questions related to the extent of the right, and the manner in which the right can or ought to be exercised. All members who have intervened on these matters of privilege have touched on these fundamental questions in one way or another. In addition, the Chair has been asked to determine whether or not the order has been complied with, and if not, whether this constitutes prima facie a contempt of the House. La deuxième question que doit...
A second matter before the Chair is the contention made primarily by the member for Scarborough-Rouge River that witnesses were intimidated by answers given in question period by the Minister of National Defence, and that a letter written by an official from the Department of Justice was contemptuous of the House in setting out for potential witnesses a false basis for refusing to answer questions in a committee of this House. Arguments were also made in relation to a third theme, namely the form, clarity and procedural validity of the December 10th order of the House. These issues arose when the Parliamentary Secretary to the Government House Leader contended on March 31st, 2010, that the order of December 10th was fatally flawed in that it seeks documents that he claims can only be obtained by way of an address to the Governor-General. Related issues were brought to the Chair's attention on the same day by the Minister of Justice, who stated at page 1225 of the debates, and I quote, "Mr. Speaker, as you will recall, the December order called for uncensored documents. It listed 8 different categories of documents to be produced. The order did not specify exactly when such documents should be produced, who should produce them, or to whom they should be produced. The order made no reference to the confidential information being protected." End of quotation.
Chair wishes to address concerns the issue of accommodation and trust, which a number of members on both sides of the House have raised. Several members have made reference to the need to safeguard confidential information that, in the words of the Minister of Justice, is found at page 7,881 of the debates of December the 10th, 2009, and I quote, "could, if disclosed, compromise Canada's security, national defence and international relations," end of quote. More significantly, a number of members have indicated that they wish to find a way to accommodate the desire of the House for information while also accommodating the desire of the government to protect sensitive information. The first arguments the Chair wishes to address are those related to the form, clarity and procedural validity of the December the 10th order. The Minister of Justice has called into question the clarity of the order. On reading the order, it is abundantly clear to the Chair that it is the government that is expected to produce the documents demanded, and that, in the absence of instructions to the contrary, the documents are to be tabled in the House in the usual manner. In this sense, the Minister and the Parliamentary Secretary are correct in asserting that no provision is made in the order for confidential treatment of the material demanded. The Chair will return to this aspect of the question later in this ruling. En ce qui concerne l'échéance...
As to when the material is to be tabled, the order says very clearly, quote-unquote, forthwith. House of Commons Procedure and Practice, 2nd edition, at page 475 states, and I quote, "If the House has adopted an order for the production of a document, the order should be complied with within a reasonable time. However, the Speaker has no power to determine when documents should be tabled." End of quotation.
Validity of the order as well as its form, the Chair wishes to draw the attention of the House to Bourrineau's Parliamentary Procedure and Practice in the Dominion of Canada, 4th edition, where it states at pages 245 to 246, et je cite, previous to the session of 1876, it was customary to move for all papers by address to the Governor-General. But since that time, the regular practice of the English Houses has been followed. It is now the usage to move for addresses only with respect to matters affecting imperial interests, the royal prerogative, or the Governor in Council. On the other hand, it is the constitutional right of either House to ask for such information as it can directly obtain by its own order from any department or officer of the government. Papers may be directly ordered when they relate to canals and railways, post office, customs, militia, fisheries, dismissal of public officers, harbours and public works, and other matters under the immediate control and direction of the different departments of the government." End of quote. As this passage makes clear, an order is issued when seeking papers that fall under the, quote, "immediate control and direction of the different departments of the government," end of quote. As an example, in the case of the documents related to the Chief of the Defence Staff referred to by the Parliamentary Secretary, it is simply not credible to claim that these documents are not under the control of the government. Le secrétaire parlementaire a invoqué.
The Parliamentary Secretary has referred to certain rulings of my predecessors in making his arguments, and has also provided additional material in support of his contention. The Chair has examined these precedents, a ruling from 1959 by Mr. Speaker Missioner and a ruling from 1982 by Madam Speaker Sauvé, but is not convinced that they directly support the particular circumstances faced by the House in this case.
This issue has to do with the documents tabled without prejudice so far by the government in response to the order of December the 10th. The Chair wishes to point out that of the documents tabled, several appear to fall into the categories which the Parliamentary Secretary claims require an address before they can be produced. In addition, the fact that these documents have been tabled has been cited by the government as a gesture of good faith on its part and an indication that it is complying to the extent that it feels it can with the order of December the 10th. Enfin, comme l'affaire...
Finally, as the member for St John's East noted, in response to objections raised at the time debate was commencing on the original motion, a decision was rendered that the motion was in order. Consequently, the House went on to debate and decide the matter. The House has expressed its will, and that is where the matter now stands. I have considered the arguments put forward, and for the reasons stated above, the Chair concludes that it was procedurally acceptable for the House to use an order and not an address to require the production of these documents.
The allegations related to witness intimidation. The member for Scarborough-Rouge River has contended that the comments made by the Minister of National Defence in reply to a question during oral questions on December the 1st, 2009, amounted to intimidation. He argued that the Minister's contention that the documents in question could be released to the Special Committee on the Canadian Mission in Afghanistan only under the provisions of the Canada Evidence Act was wrong and misleading, obstructed the House, and intimidated witnesses, especially armed forces personnel and public servants, thereby lessening the likelihood of their compliance with House requests and orders. Par ailleurs, l'honorable député de...
The honourable member for Scarborough-Rouge River also took exception to a December 9th, 2009 letter to the Law Clerk and Parliamentary Counsel of the House from an Assistant Deputy Minister from the Department of Justice on the obligations of witnesses before committees and on the obligation to provide documents ordered by committees. He argued that the letter constituted a contempt of the House by setting out for witnesses a false basis for refusing to provide disclosure to the House or its committees after being ordered to do so. In particular, the member for Scarborough-Rouge River stressed that if the contents of the letter were crafted with ministerial approval, it could constitute a conspiracy to undermine Parliament and the ability of the House to carry on its constitutional functions.
Responded that the remarks made by the Minister of National Defence were simply matters of debate and differences of opinion between members. Of the second complaint, the government took the view that the letter from the justice official constituted nothing more than an exchange of views between legal professionals and that it could not be construed as, quote, an attempt to intimidate the government witnesses, end of quote. The honourable member for Scarborough-Rouge River had argued that the minister's reply constituted a slander of Parliament's core powers to hold the government to account and thus was a contempt. However, particularly since this exchange between the minister and the member for Vancouver South occurred during question period, I find that I must agree with the parliamentary secretary's characterization of this exchange as a matter of debate. I have no need to remind the House that freedom of speech is one of our most cherished rights. Although members may disagree with the comments made by the minister, I cannot find that the minister's words in and of themselves constitute witness intimidation. Hence, nor do they constitute prima facie a contempt of the House.
As for the member of Scarborough-Rouge River's other concern regarding the letter from the Assistant Deputy Minister, the procedural authorities are clear that interference with witnesses may constitute a contempt. House of Commons Procedure and Practices, second edition, at page 1070, states, and I quote, tampering with a witness or in any way attempting to deter a witness from giving evidence may constitute a breach of parliamentary privilege. End of quotation. It is reasonable to assume that a letter signed by an Assistant Deputy Minister, acting under the authority of the Minister of Justice, is an expression of the government's view on an issue. And given that its contents have been widely reported and circulated, the letter could leave the impression that public servants and government officials cannot be protected by Parliament for their responses to questions at a parliamentary committee, when this is not the case.
I would like to draw to the attention of honourable members the section of the letter in question, which the member for Scarborough-Rouge River tabled in the House on March 18, 2010, where the Assistant Deputy Minister lays out a view of the duties of public servants in relation to committees of the House. The letter states, and again I quote, "Of course there may be instances where an Act of Parliament will not be interpreted to apply to the Houses of Parliament or their committees. However, that does not mean automatically that government officials, who are agents of the executive, not the legislative branch, are absolved from respecting duties imposed by a statute enacted by Parliament or by requirements of the common law, such as solicitor-client privilege or Crown privilege. This is so even if a parliamentary committee, through the exercise of parliamentary privilege, may extend immunity to witnesses appearing before it. A parliamentary committee cannot waive a legal duty imposed on government officials. To argue to the contrary would be inimical to the principles of the rule of law and parliamentary sovereignty. A parliamentary committee is subordinate, not superior to, the legislative will of Parliament as expressed in its enactments." End quote. Je suis préoccupé par le fait.
It does concern me that the letter of the Assistant Deputy Minister could be interpreted as having a chilling effect on public servants who are called to appear before parliamentary committees.
Les députés de Scarborough.
As contended the members for Scarborough-Rouge River and Toronto Centre, this could be especially so if the view put forth in the letter formed the basis of a direction given by department heads to their employees who have been called to testify before parliamentary committees.
Parallèlement, il est
At the same time, it is critically important to remember in this regard that our practice already recognizes that public servants appearing as witnesses are placed in the peculiar position of having two duties. As House of Commons Procedure and Practice, second edition states at pages 1068 and 1069, particular attention is paid to the questioning of public servants. The obligation of a witness to answer all the questions put by the committee must be balanced against the role that public servants play in providing confidential advice to their ministers.
En outre, les comités.
In addition, committees ordinarily accept the reasons that a public servant gives for declining to answer a specific question or series of questions which may be perceived as a conflict with the witness's responsibility to the minister, end of quote. The solution for committees facing such situations is to seek answers from those who are ultimately accountable, namely the ministers themselves.
It's been argued that there may be a chilling effect which could come dangerously close to impeding members of committees in carrying out their duties. However, I remind the House that this letter was sent to our law clerk, so on balance I would need to see the use made of this letter, in particular whether it was ever presented to a person who was scheduled to testify before the special committee with the intent of limiting the person's testimony. As things stand, there does not appear to the Chair to be sufficient evidence for me to conclude that this letter constitutes a direct attempt to prevent or influence the testimony of any witness before a committee, and for these reasons I cannot find there is a prima facie question of contempt on this point. I now turn to the questions of the House's right to order the production of documents and the claim that the government has failed to comply with the order of the House. The Honourable Member for Kootenay East argues that even if the documents were provided to the committee could not, given their sensitive nature, make use of them publicly. However, I cannot agree with his conclusion that this obviates the government's requirement to provide the documents ordered by the House. To accept such a notion would completely undermine the importance of the role of parliamentarians in holding the government to account. Before us are issues that question the very foundations upon which our parliamentary system is built. In a system of responsible government, the fundamental right of the House of Commons to hold the government to account for its actions is an indisputable privilege and, in fact, an obligation. Embedded in our Constitution, parliamentary law, and even in our standing orders, it is the source of our parliamentary system from which other processes and principles necessarily flow. And it's why that right is manifested in numerous procedures of the House, from the daily question period to the detailed examination by committees of estimates, to reviews of the accounts of Canada, to debate, amendment and votes on legislation.
As I noted on December 10, 2009, House of Commons Procedure and Practice, 2nd edition states at page 136, and I quote again, "By virtue of the preamble and section 18 of the Constitution Act 1867, Parliament has the ability to institute its own inquiries, to require the attendance of witnesses, and to order the production of documents, rights which are fundamental to its proper functioning. These rights are as old as Parliament itself." End of quote. And on pages 978 to 979 of the same work, and I quote again, "The standing orders do not delimit the power to order the production of papers and records. The result is a broad, absolute power that, on the surface, appears to be without restriction. There is no limit on the type of papers likely to be requested. The only prerequisite is that the papers exist in hard copy or electronic format, and that they are located in Canada. No statute or practice diminishes the fullness of the power rooted in the House privileges, unless there is an explicit legal provision to that effect, or unless the House adopts a specific resolution limiting the power. The House has never set a limit on its power to order the production of papers and records." End of quote.
4th edition states at page 70, "The Senate and the House of Commons have the right, inherent in them as legislative bodies, to summon and compel the attendance of all persons within the limits of their jurisdiction as witnesses, and to order them to bring with them such papers and records as may be required for the purpose of an inquiry." End of quote. In the arguments presented, the Chair has heard this power described as unabridged, unconditional, unqualified, absolute, and furthermore, one which is limited only by the discretion of the House itself. But this view is not shared by all, and so it is a privilege whose limits have now been called into question. The government's view is that such an unqualified right does not exist for either House of Parliament or their committees. The Executive, the holder of the sensitive information sought by the House, has competing obligations. On the one hand, it recognizes that there is an exception of transparency so that government actions can be properly monitored to ensure that they respect the law and international agreements. On the other hand, the government contends that the protection of national security, national defense, and international relations demands that some information remain secret and confidential, out of the reach of those obliged to scrutinize its actions and hold it to account. In his March 31st intervention, the Minister of Justice quoted from the 1887 parliamentary treatise of Alpheus Todd to support the view that, quote, a due regard to the interests of the state occasionally demand that information sought for by members of the legislature should be withheld at the discretion and upon the responsibility of ministers, end of quote. The minister also cited Bourrineau in 1884, observing that the government may, quote, feel constrained to refuse certain papers on the ground that their production would be injurious to public interest, end of quote. Had he read a little further, he might have found the following statement by Bourrineau at page 281, and I quote, but it must be remembered that under all circumstances it is for the House to consider whether the reasons given for refusing the information are sufficient. The right of Parliament to obtain every possible information on public questions is undoubted, and the circumstances must be exceptional and the reasons very cogent when it cannot be at once laid before the Houses. End of quote.
As the members for Saint Jean and Joliette commented on March 25th, 2010, Bourrineau's second edition notes that even in instances where a minister refuses to provide documents that are requested, it is clear that it is ultimately still up to the House to determine whether grounds exist to withhold documents. Bourrineau, in referring to procedures for notices of motion for production of papers, wrote at pages 337 and 338, and once again I will quote,
ministers refuse information, especially at some delicate stage of an investigation or negotiation, and in such instances the House will always acquiesce when sufficient reasons are given for the refusal. But it must be remembered that under all circumstances it is for the House to consider whether the reasons given for refusing the information are sufficient. Dans la deuxième édition, fin de citation.
End of quote. Joseph Mango's Parliamentary Privilege in Canada's second edition also supports the need for Parliament to have a voice in these very matters when it states at page 190, and once again I quote, the only limitations, which could only be self-imposed, would be that any inquiry should relate to a subject within the legislative competence of Parliament, particularly where witnesses and documents are required, and the penal jurisdiction of Parliament is contemplated. This dovetails with the right of each House of Parliament to summon and compel the attendance of all persons within the limits of their jurisdictions. End of quote.
Similarly, in Erskine May 23rd edition, in a discussion of the exclusive cognizance of proceedings at page 102, we find the following, and again I quote, underlying the Bill of Rights, 1689, is the privilege of both Houses to the exclusive cognizance of their own proceedings. Both Houses retain the right to be sole judge of the lawfulness of their proceedings and to settle or depart from their own codes of procedure. This is equally the case where the House in question is dealing with a matter which is finally decided by its sole authority, such as an order or resolution, or whether, like a bill, it is the joint concern of both Houses. In David McGee's Parliamentary Practice in New Zealand, second edition at page 621, he asserts, and I quote, the Australian legislation, referring to the Parliamentary Privileges Act 1987, in respect of Article 9 of the Bill of Rights, may be taken to indicate the types of transactions falling within the term proceedings of Parliament, end of quote. He then goes on to state that such proceedings to which privilege attaches includes, quote, the presentation of a document to a House or a committee, end of quote. Odger's Australian Senate Practice, 12th edition at page 51, states clearly, quote, parliamentary privilege is not affected by provisions in statutes which prohibit in general terms the disclosure of categories of information. Statutory provisions of this type do not prevent the disclosure of information covered by the provisions to a House of the Parliament or to a parliamentary committee in the course of a parliamentary inquiry. They do not prevent committees seeking the information covered by such provisions or persons who have that information providing it to committees." End of quote. In light of these various authorities, the Chair must conclude that the House does indeed have the right to ask for the documents listed in the order of December the 10th, 2009. With regard to the extent of the right, the Chair would like to address the contention of the Minister of Justice made on March 31st that the order of the House of December 10th is a breach of the constitutional separation of powers between the Executive and the Legislature. Having noted that the three branches of government must respect the legitimate sphere of activity of the others, the Minister argued that the order of the House was tantamount to an unlawful extension of the House's privileges. This can only be true if one agrees with the notion that the House's power to order the production of documents is not absolute. The question then would be whether this interpretation subjugates the Legislature to the Executive. It is the view of the Chair that accepting an unconditional authority of the Executive to censor the information provided to Parliament would in fact jeopardize the very separation of powers that is purported to lie at the heart of our parliamentary system and the independence of its constituent parties. Furthermore, it risks diminishing the inherent privileges of the House and its members, which have been earned and must be safeguarded. As has been noted earlier, the procedural authorities are categorical in repeatedly asserting the powers of the House in ordering the production of documents. No exceptions are made for any category of government documents, even those related to national security. And therefore, the Chair must conclude that it is perfectly within the existing privileges of the House to order production of the documents in question. Bearing in mind that the fundamental role of Parliament is to hold the government to account, as the servant of the House and the protector of its privileges, I cannot agree with the government's interpretation that ordering these documents transgresses the separation of powers and interferes with the spheres of activity of the executive branch.
But what of the House's responsibility regarding the manner in which this right can or ought to be exercised? The authorities cited earlier all make reference to the long-standing practice whereby the House has accepted that not all documents demanded ought to be made available in cases where the government asserts that this is impossible or inappropriate for reasons of national security, national defense, or international relations. O'Brien and Bosque at page 979 states, and I quote, "It may not be appropriate to insist on the production of papers and records in all cases," end of quote. The basis for this statement is a 1991 report by the Standing Committee on Privileges and Elections, which, as recorded on page 95 of the Journals of May 29th, 1991, pointed out, and I quote, "The House of Commons recognizes that it should not require the production of documents in all cases. Considerations of public policy, including national security, foreign relations, and so forth, enter into the decision as to when it is appropriate to order the production of such documents," end of quote.
In his comments on this aspect of the matter before us, the Parliamentary Secretary to the Government House Leader referred to my ruling of June 8, 2006, where I stated that national security, when asserted by a minister, was sufficient to set aside a requirement to table documents cited in debate. The example cited by the Parliamentary Secretary related strictly to documents that have been cited by a minister in the absence of any other explicit expression of interest by the House in the said documents. Ayant relu la décision.
Having reviewed the June 8th ruling, it is clear to the Chair that there is a difference between the practice of the House, which allows a minister, on the sole basis of his or her judgment, to refrain from tabling a cited document for reasons of confidentiality and national security, and an order duly adopted by the House following notice and debate requiring the tabling of documents. Another important distinction between the order adopted by the House on December 10, 2009, and the practice respecting notices of motion for the production of papers referred to by the member for St. John's East on April 12th is that, with respect to such notices, there is an opportunity for a minister or parliamentary secretary to indicate to the House that the notice is acceptable to the government, subject to certain reservations such as confidentiality or national security.
Prior to the adoption of the motion is fully aware that some documents will not be produced if the motion is adopted. If the House does not agree, the motion must either be transferred for debate or be put immediately to the House without debate or amendment. Something similar happened on December the 10th, 2009. Before the House voted on the motion that became an order to produce documents, the Ministers of Justice, National Defence and Foreign Affairs all rose in the House to explain the reasons why the documents in question should not be made available. This is in keeping with what Bourneau refers to as the government's responsibility to provide, quote, reasons very cogent, unquote, for not producing documents. Under normal circumstances, reflecting on past history in the House, these assertions by the government might well have been found to be acceptable by the House. In the current circumstances, however, the reasons given by the government were not found to be sufficient. The House debated the matter and voted to adopt an order for the production of documents despite the request of the government. The reason for this, it seems, has to do with the issue of accommodation and trust. On December the 10th, 2009, as found at page 7,877 of the debates, I stated that, quote, it is unfortunate, if I may make this comment, that arrangements were not made in committee to settle this matter there, where these requests were made and where there might have been some agreement on which documents and which format would be tabled or made available to members. How they were to be produced, or however it was to be done, I do not know, but obviously that has not happened, end quote.
Several members have made the point that there are numerous ways that the documents in question could have been made available without divulging state secrets, and acknowledged that all sides in the House needed to find a way to respect the privileges and rights of members of Parliament to hold the government to account, while at the same time protecting national security. The government, for its part, has sought to find a solution to the impasse. It has appointed former Supreme Court Justice Frank Iacobucci and given him a mandate to examine the documents and to recommend to the Minister of Justice and Attorney General what could safely be disclosed to the House. The government has argued that in mandating this review by Mr. Iacobucci, it was taking steps to comply with the order consistent with its requirements to protect the security of Canada's armed forces and Canada's international obligations. However, several members have pointed out that Mr. Iacobucci's appointment establishes a separate and parallel process outside of parliamentary oversight and without parliamentary involvement. Furthermore, and in my view perhaps more significantly, Mr. Iacobucci reports to the Minister of Justice. His client is the government.
The authorities I have cited are unanimous in the view of the House's privilege to ask for the production of papers, and many go on to explain that accommodations are made between those seeking information and those in possession of it to ensure that arrangements are made in the best interests of the public they both serve. Certainly from the submissions I have heard, it is evident to the Chair that all members take seriously the sensitive nature of these documents and the need to protect the confidential information they contain. The Chair must conclude that it is within the powers of the House of Commons to ask for the documents sought in the December 10th order it adopted. Now it seems to me that the issue before us is this: is it possible to put in place a mechanism by which these documents could be made available to the House without compromising the security and confidentiality of the information they contain. In other words, is it possible for the two sides, working together in the best interests of the Canadians they serve, to devise a means where both their concerns are met? Surely that's not too much to hope for. The member for Toronto Centre has made a suggestion, as recorded on page 615 of the debates of March 18, 2010. I quote, "What we believe can be done is not beyond the ability of the House. It is done in many other parliaments. Indeed, there are circumstances under which it has even been done in this House. It's perfectly possible for unredacted documents to be seen by members of Parliament who have been sworn for the purpose of looking at these documents." End of quote. O'Brien and Bosk at page 980 points to ways of seeking a compromise for members to gain access to otherwise inaccessible material. And I quote, "Normally this entails putting measures in place to ensure that the record is kept confidential while it is being consulted. In-camera review, limited and numbered copies, arrangements for disposing of or destroying the copies after the committee meeting, etc." End quote. In some jurisdictions, such as the Legislative Council in the Australian state of New South Wales, and I would refer members to New South Wales Legislative Council practice by Lovelock and Evans at page 481, mechanisms have been put in place which satisfy the confidentiality concerns of the government as well as those of the legislature. Procedures provide for independent arbiters recognized by both the executive and the legislature to make determinations on what can be disclosed when a dispute arises over an order for the production of documents. Il sera difficile de trouver un terrain.
Finding common ground will be difficult. There have been assertions that colleagues in the House are not sufficiently trustworthy to be given confidential information, even with appropriate security safeguards in place. I find such comments troubling. The insinuation that members of Parliament cannot be trusted with the very information that they may well require to act on behalf of Canadians runs contrary to the inherent trust that Canadians have placed in their elected officials and which members require to act in their various parliamentary capacities. The issue of trust goes in the other direction as well. Some suggestions have been made that the government has self-serving and ulterior motives for the redactions in the documents tabled. Here, too, such remarks are singularly unhelpful to the aim of finding a workable accommodation and ultimately identifying mechanisms that will satisfy all actors in this matter.
That the House and the government have essentially an unbroken record of some 140 years of collaboration and accommodation in cases of this kind. It seems to me that it would be a signal failure for us to see that record shattered in the third session of the 40th Parliament because we lack the will or the wit to find a solution to this impasse. The House has long understood the role of the government as defender of the realm and its heavy responsibilities in matters of security, national defence and international relations. Similarly, the government understands the House's undoubted role as the grand inquest of the nation and its need for complete and accurate information in order to fulfill its duty of holding the government to account. Examples have been cited of mechanisms that might satisfy the competing interests of both sides in this matter. In view of the grave circumstances of the current impasse, the Chair believes that the House ought to make one further effort to arrive at an interest-based solution to this thorny question. Accordingly, on analysing the evidence before it and the precedents, the Chair cannot but conclude that the government's failure to comply with the order of December the 10th, 2009 constitutes prima facie a question of privilege. I will allow House leaders, ministers and party critics time to suggest some way of resolving the impasse, for it seems to me we would fail the institution if no resolution can be found. However, if in 2 weeks' time the matter is still not resolved, the Chair will return to make a statement on the motion that will be allowed in the circumstances. In the meantime, of course, the Chair is disposed to assist the House in any way it can, and I'm open to suggestions on any particular role that I, as your Speaker, can play. I thank the House for its attention. Sorry that was so long. I'm now prepared to rule on the question of privilege raised on February the 7th, 2011 by the Honourable Member for King's Hants concerning the production of documents ordered by the Standing Committee on Finance.
I would like to thank the Honourable Member for King's Hants for having raised this matter, as well as the Honourable Parliamentary Secretary to the Government House Leader and the members for Mississauga South, Windsor-Tecumseh and Notre-Dame-de-Grâce-Lachine for their interventions.
The member for King's Hants explained that on November 17, 2010, the Standing Committee on Finance adopted a motion ordering the production of documents relating to corporate profits and taxes and the costs of various justice bills. The government, citing cabinet confidence as a reason, declined on 3 separate occasions to produce the information sought. The committee then presented its 10th report to the House on February the 7th, 2011, to draw the attention of the House to this matter. More specifically, the member for King's Hants contended that the refusal to provide the information constituted a breach of this House's privileges, and moreover, the refusal to provide a reasonable explanation as to why the information was deemed to constitute a cabinet confidence was tantamount to contempt. There was a considerable lapse of time before the government formally responded to this question of privilege. Before it did so, on February 17, 2011, in the debates at page 8324, the government House Leader rose in the House to table, quote, information on our government's low tax and tough on crime agenda as requested by certain members of Parliament, end of quote. Only after this, on February the 28th, 2011, did the Parliamentary Secretary of the Government House Leader return to the House to present his case on the question of privilege. He argued that even though, in his view, the Standing Committee on Finance, in its 10th report, did not ask the House to order the production of the documents in question, the government, despite the absence of such a House order, had willingly tabled information which preserved, quote, the confidentiality required around documents which are classified as cabinet confidences, yet meets the request for specific data contained within the documents by which by its nature is not a cabinet confidence, end of quote. Later the same day, the member for King's Hants made further arguments in the House to indicate his dissatisfaction with the government's response. He stated that he believed the government had, quote, failed to provide all the documents or provide any reasonable explanation as to why these documents cannot be provided, end of quote.
In interventions since that time, the government has maintained that the government has provided the information requested, implying that all of it has been provided. It should be noted that at the same time as interventions were being made on this question of privilege, the House was proceeding on a separate track on what was essentially the same matter. Thus, on February 17, 2011, the House was debating an opposition motion ordering the production of the same documents demanded by the Standing Committee on Finance. In a subsequent vote on the motion held on February 28, 2011, the House adopted the motion, thus setting a deadline of March 7, 2011 for the production of the documents in question.
Dealing first with the question of whether or not the House or its committees have the authority to order the production of documents, let me restate in part my April 27, 2010 ruling with respect to the production of documents related to Afghan detainees. At the time, I stated at page 2043 of the debates, and I'll quote myself, procedural authorities are categorical in repeatedly asserting the powers of the House in ordering the production of documents. No exceptions are made for any category of government documents. Therefore, the Chair must conclude that it is perfectly within the existing privileges of the House to order production of the documents in question. End of quote.
I also quoted House of Commons Procedure and Practice, second edition, at pages 978 and 979, which states, and I quote once again, the standing orders do not delimit the power to order the production of papers and records. The result is a broad absolute power that on the surface appears to be without restriction. There is no limit on the type of papers likely to be requested. The only prerequisite is that the papers exist in hard copy or electronic format and that they are located in Canada. No statute or practice diminishes the fullness of the power rooted in the House privileges unless there is an explicit legal provision to that effect, or unless the House adopts a specific resolution limiting the power. The House has never set a limit on its power to order the production of papers and records." End of quote.
Pour ceux qui
With respect to the power of committees to order the production of documents, Standing Order 108.1a is clear that they can, quote, "send for persons, papers, and records," unquote. O'Brien and Bosque at page 978 expands on this point. Once again, I quote, "The standing orders state that standing committees have the power to order the production of papers and records, another privilege rooted in the Constitution that is delegated by the House," unquote.
The power of committees of the House to order papers is indistinguishable from that of the House. With these well-established privileges and principles in mind, and in order to assess properly whether or not the order flowing from the Standing Committee on Finance has been complied with, I undertook a review of what was tabled. The Chair was helped in this by the committee's order, which was quite explicit in the information it sought, even going so far as to list the bills for which information was required. While the Chair does not judge the quality of documents tabled in the House, it is clear from a cursory examination of the material tabled that, on its face, it does not provide all the information ordered by the committee. While the Chair finds this in and of itself unsettling, what is of greater concern is the absence of an explanation for the omissions. And at the very least, based on the indisputable right of the committee to order these documents, this is required. Only then can the House determine whether the reasons given are sufficient or satisfactory. The need to provide reasons to the House is clear. On page 281 of Bourneau's Parliamentary Procedure and Practice in the Dominion of Canada, 4th edition, it states, et je cite, "Néanmoins,"
I quote, "but it must be remembered that under all circumstances it is for the House to consider whether the reasons given for refusing the information are sufficient. The right of Parliament to obtain every possible information on public questions is undoubted, and the circumstances must be exceptional and the reasons very cogent when it cannot be at once laid before the Houses," unquote.
The debates on this question, and while initially Cabinet confidence was cited as a reason not to produce any of the documents, despite this the Government saw fit to partially comply with the committee order, and a tabling of some material did eventually take place. Since then, no further reasons have been given as to why the balance of the documents should not or will not be tabled. It may be that valid reasons exist. That's not for the Chair to judge. A committee empowered to investigate the matter might, but the Chair is ill-equipped to do so. However, there's no doubt that an order to produce documents is not being fully complied with, and this is a serious matter that goes to the heart of the House's undoubted role in holding the Government to account. And for these reasons, the Chair finds that there are sufficient grounds for finding a prima facie question of privilege in this matter. Before I invite the member for King's Hants to move his motion, however, the Chair wishes to explain the procedural parameters that govern such motions. House of Commons Procedure and Practice, 2nd edition, at pages 146 and 147, states that, quote, "In cases where the motion is not known in advance, the Speaker may provide assistance to the member if the terms of the proposed motion are substantially different from the matter originally raised. The Speaker would be reluctant to allow a matter as important as a privilege motion to fail on the ground of improper form. The terms of the motion have generally provided that the matter be referred to committee for study or have been amended to that effect." End of quote. I hasten to add that the powers of the Speaker in these matters are robust and well known. In 1966, Mr. Speaker Lamoureux, having come to a finding of prima facie privilege on a matter, ruled a number of motions out of order. And as House of Commons Procedure and Practice, 2nd edition, tells us at page 147 and footnote 371, in doing so, Mr. Speaker Lamoureux, quote, "more than once pointed out that it was Canadian practice to refer such matters to committee for study and suggested that this should be the avenue pursued." End of quote. The Chair is, of course, aware of exceptions to this practice, but in most, if not all of these cases, circumstances were such that a deviation from the normal practice was deemed acceptable, or there was a unanimous desire on the part of the House to proceed in that fashion. So with this guidance in mind, I will briefly, soon anyway, recognize the Honourable Member for King's Hants so that he can propose his motion. But before he proceeds, I have another ruling on another matter, which I will deliver. I better have some water first. I'm now prepared to rule on the question of privilege raised on February 17, 2011 by the Honourable Member for Scarborough-Guildwood, stemming from the presentation of the 6th report of the Standing Committee on Foreign Affairs and International Development and the allegedly misleading statements made by the Minister of International Cooperation. I
would like to thank the member for Scarborough-Guildwood, as well as the Honourable Parliamentary Secretary to the Government House Leader, and the members for Ottawa Centre, Joliette, Scarborough, Rouge River, Vancouver East, Guelph, Eglinton Lawrence, Beaches East York, Yukon, and Winnipeg North for their contributions on this important matter.
Members will know this matter was first raised by the member for Scarborough-Guildwood on December the 13th, 2010. In my ruling of February the 10th, 2011, I explained that I was unable to, quote, find evidence and documents properly before the House to suggest that the Minister's statements to the House were deliberately misleading, end of quote. Accordingly, I declined to find that a prima facie question of privilege existed. On February the 14th, 2011, the Minister of International Cooperation made a statement in the House to clarify matters related to the funding application for Kairos. While acknowledging that the way in which this case has been handled was unfortunate, she asserted that she had neither intentionally nor knowingly misled the House or the committee. She also stated that, quote, if some were led to conclude that my language implied that the Department and I were of one mind on this application, then I apologize, end of quote. On
February 17, 2011, the 6th report of the Standing Committee on Foreign Affairs and International Development was presented to the House. It is a short report which focuses primarily on testimony by the Minister and her officials on December 9, 2010 in relation to the process that led to the rejection of a funding application by Kairos. In particular, much attention is given to determining how the word "not" made its way into the assessment of the Kairos funding application submitted to the Minister for approval. The last part of the report links this testimony with other information before the House and draws, and I quote, attention to what appears to be a possible breach of privilege.
The member for Scarborough-Guildwood and other members have argued that the Minister has made statements in committee that are different from those made in the House or provided to the House in written form. Indeed, these members have argued that the material available shows that contradictory information has been provided. As a result, they argue, this demonstrates that the Minister has deliberately misled the House, and as such, a prima facie case of privilege exists. For his part, the Parliamentary Secretary to the Leader of the Government in the House argued that the 6th report of the Standing Committee contained no accusations or other suggestions that the rights or dignity of the House had been compromised or that the Committee had been misled either unintentionally or deliberately. Claiming that, in fact, no direct accusation has been made, he asked, quote, what charge is there to be answered, end of quote. He suggested that it was improper for a committee to report that, quote, an undescribed and undefined breach of privilege may have occurred, end of quote, and emphasized that the Minister had given clear, accurate, and honest answers. He also stated that it was not contradictory for the Minister to state that while she did not know who inserted the word "not," it had indeed been done on her instructions. Now
that the Standing Committee in its 6th report has made available to the House material not previously before us, I must take its findings into consideration, measuring them against other material, including statements in the House and answers to oral and written questions. But I caution that the Speaker has a very particular and limited role in the conclusions to be drawn. In a ruling given on March 21st, 1978, at page 3975 of Debates, which is also referred to in Mago's Parliamentary Privilege in Canada, second edition. At page 227, Mr. Speaker Jerome quoted a British Procedure Committee report of 1967, which states in part, and I quote,
when he has to decide whether to grant precedence over other public business to a motion which a member who has complained of some act or conduct as constituting a breach of privilege desires to move, should be not, do I consider that, assuming that the facts are as stated, the act or conduct constitutes a breach of privilege, but could it reasonably be held to be a breach of privilege, or, to put it shortly, has the member an arguable point? If the Speaker feels any doubt on the question, he should, in my view, leave it to the House." End of quote. C'est en gardant à l'esprit ce principe.
It is with this principle in mind that I've taken great care to study the evidence in view of the very serious allegations regarding the conduct of a minister who, as a result, has been subjected to harsh and public criticism which has potentially damaging to her reputation.
As the committee has reported, when asked who inserted the word "not" in the assessment of the Kairos funding application in testimony, the minister twice replied that she did not know. In a February 14th statement to the House, while she did not indicate that she knew who inserted the word "not," the minister addressed this matter by stating that the "not" was inserted at her direction. At the very least, it can be said that this has caused confusion. The minister has acknowledged this and has characterized her own handling of the matter as, quote, "unfortunate," end of quote. Yet, as is evident from hearing the various interventions that have been made since then, the confusion persists. As the member for Scarborough-Rouge River told the House, quote, "This has confused me, it has confused Parliament, it has confused us in our exercise of holding the government to account, whether it is the Privy Council, whether it is the Minister, whether it is public officials. We cannot do our job when there is that type of confusion," end of quote. The Chair has faced a somewhat analogous situation before. In January 2002, the Minister of National Defence had made statements in the House regarding Afghan detainees that ultimately also caused confusion and led to a question of privilege being raised. In that case, two versions of events had been presented to the House. In that case, as in this one, the Minister assured the House that there was no intention to mislead. At that time, in finding a prima facie case, I stated at page 8581 of the debates of February 2002 that I was, quote, "prepared as I must be to accept the Minister's assertion that he had no intention to mislead the House. Nevertheless, this remains a very, very difficult situation," end of quote. I then went on to conclude that, quote, "the situation before us where the House is left with two versions of events is one that merits further consideration by an appropriate committee, if only to clear the air," end of quote. In keeping with this fairly recent precedent, and mindful of the ruling by Mr. Speaker Jerome cited earlier, the Chair is of the view that sufficient doubt exists to warrant a finding of prima facie privilege in this case, and accordingly, I will invite the member for Scarborough-Guildwood to move his motion in due course. But at the moment, I wish to return to the honourable member for King's Hants to move his motion on the earlier case.